I was watching this bloke the other day, practically foaming at the mouth, draped in a Union Jack like it was some kind of superhero cape.
Oh, right.
He was going on this huge tirade about protecting our culture. He was terrified, I mean, genuinely terrified, that Britain was being infiltrated by, intolerant ideologies that don't respect our way of life.
The familiar argument.
He just kept banging on about how we needed to stand up for freedom and stop these outside forces from changing who we are. But then the conversation took a really bizarre turn.
How so?
I asked him what his solution was. And without a hint of irony, he just looked me dead in the eye and said, we need to scrap the Equality Act, get rid of all this woke fairness rubbish to take back control.
Wow.
I just stared at him. I mean, here was a man claiming to defend British values, yet he was actively, cheering for the destruction of the very legal framework that actually defines those values.
Fairness, dignity.
Fairness, dignity, queer liberation, all of it. It was this fascinating, if pretty disturbing study in cognitive dissonance. He was so afraid of an intolerant future that he was volunteering to build it himself, brick by repressive brick.
Right.
It hit me that he wasn't really a patriot. He was like a pyrophobic suffering from pyromania. He was trying to burn down the house just to prove he knows how to handle fire.
That's a powerful metaphor.
And it really begs the question. What happens when the people screaming the loudest about saving the country are the ones handing the sledgehammers to its enemies?
A very unsettling question.
Okay, let's unpack this. This deep dive is for you as we examine the Equality Act 2010, the furious political critique that's seeking its demise, and this high-stakes paradox of cultural defense.
We're really digging into that fundamental conflict, aren't we? The historic principle of equal treatment for the individual
versus the progressive goal of achieving equal outcomes for all groups, and why that conflict has turned the Equality Act from this widely accepted piece of foundational legislation into maybe the most radioactive document in British politics.
It's a huge shift.
Before we get into all the fury, we really have to establish the groundwork. What exactly is the Equality Act 2010? Why was it so significant when it was first introduced? Was it just another new law, or was it a total restructuring?
Oh, it was a total restructuring. The Equality Act, the EA 2010, it was a landmark piece of legislation precisely because it consolidated and reformed the entire fragmented structure of British anti-discrimination law.
Fragmented is the word. It was a real mess before, wasn't it?
It was. Over several decades, we had accumulated this really complex web of statutes, each one dealing separately with race, sex, disability, and so on.
Which meant what in practice? Different rules for different things.
Exactly. It meant the protection standards, the exemptions, the enforcement mechanisms. They were often inconsistent. It was just deeply confusing for both businesses and, for ordinary citizens.
So the Act's first victory was almost logistical, bringing some clarity to an otherwise completely cluttered legal landscape.
Absolutely. The Act replaced and absorbed no fewer than 9 major pieces of prior legislation.
9.
9. I mean, think of the foundational acts it superseded. The Equal Pay Act of 1970, the Sex Discrimination Act from 75, the Race Relations Act from 76, and the Disability Discrimination Act from 1995.
So the big ones.
The big ones, plus various instruments that covered age, religion, sexual orientation. The stated goal was to create a single, simplified, coherent legal framework.
And in doing that consolidation, it basically defined what legal protection looks like in modern Britain through that famous list of protected characteristics.
Exactly. The Act provides protection against discrimination, harassment, or victimization based on 9 specific characteristics.
I'll list them. It's important.
It is. So you have age, disability, sex, sexual orientation,
marriage and civil partnership, gender reassignment,
pregnancy and maternity, race, and finally religion or belief. Those 9 became the unified legal anchors of British equality.
Meaning the rules for prohibiting discrimination are now, broadly speaking, the same, no matter which characteristic is involved.
That's the principle.
It's important to reflect on the immense political ambition that drove this law, though. While the EA is famous for the protected characteristics, there was a radical component that was, ultimately sidelined. But it definitely informs the current critique of overreach. I'm thinking of Part 1.
Yes, Part 1. The duty to reduce socioeconomic inequalities. That was indeed the most ambitious and the most controversial element of the whole thing.
I remember one cabinet minister called it socialism in one clause.
She did, and you can see why. The premise was that government shouldn't just prohibit discrimination based on identity, but that it should actively mandate that public authorities consider and work toward reducing income and wealth inequality when they make strategic decisions.
So what would that actually look like in practice if it were fully operational across the whole of the UK?
Well, it would fundamentally alter public policy. If a local authority was planning a new transport system, for example, they couldn't just consider the protected characteristics.
Let's do more.
Much more. They'd also have to document how their decision affects socioeconomic equality. So would building a new railway line benefit only the wealthy commuters, or would it actively help low-income communities get to jobs?
And the fact that this is actually enforced in Scotland?
Yes, the Scottish government did implement this duty. They call it the Fairer Scotland duty. And for the critics, that only reinforces their view that the underlying philosophy of the EA is inherently focused on, mandatory social engineering and outcome equality, not just procedural fairness.
And this really highlights the paradox we started with. Critics claim this law is alien to British tradition, but a lot of public attitude research suggests the core principles of fairness are absolutely fundamental to contemporary British identity. How do we reconcile that?
Social research on identity and citizenship is crucial here. It really confirms that the foundations of an inclusive British identity today aren't strictly cultural, they're behavioral, they're relational.
What do you mean by that?
People agree on a set of foundational behaviors: respect for the law, the ability to contribute positively to society, and crucially, an almost ironclad commitment to fair play.
Fair play.
Fair play, in this context, is the rejection of creating first- and second-class citizenship. The public overwhelmingly views the idea that you have to be white or Christian to be considered fully British as being fundamentally wrong.
So it's a core value now.
It's a core non-negotiable value. Respecting that people of different ethnicities, different faiths, different orientations are fully and equally British is seen as central. The Equality Act basically took that popular moral commitment to fair treatment and codified it. It made it enforceable in law.
That concept of fair play translating into practical everyday dignity is, I think, where the legal theory really meets human reality.
Yes, and this is where a story like Arthur's becomes so important.
The 70-year-old disabled veteran.
That's the one! He loved meeting his friends at his local pub, the Royal Oak. But for years, there were these 3 steep steps that just barred him from participating in that community ritual.
And it wasn't malice, was it?
Not at all. It was just structural exclusion. The lack of a ramp was just how the building was.
Right.
Now, the Equality Act didn't force the pub to spontaneously build a ramp overnight. But as anti-discrimination law became embedded in accessibility standards, in planning regulations, in public authority guidance, all driven by the spirit of the act, it provided the definitive legal and moral muscle for the pub to finally install that ramp.
So for Arthur,
the act wasn't bureaucratic red tape or some academic concept. It was the physical key that unlocked his access to his community and, restored his dignity.
that story is so essential because it shows the act isn't merely punitive, it's constructive.
Yeah.
It uses law to build a more inclusive physical and social environment.
It does.
It makes the proposal to just repeal it feel genuinely destructive, not just, fiscally prudent.
And that leads us directly to the most controversial aspect of the act, the part that demands this proactive inclusion. The Public Sector Equality Duty, or PSED, that's in Section 149.
PSED. It demands that public authorities have due regard to 3 specific aims when they're making decisions. So what are those 3 aims, and why is this due regard requirement so hotly contested?
So the 3 aims are, first, eliminating prohibited conduct; second, advancing equality of opportunity; and third, fostering good relations.
Okay.
The due regard requirement is what elevates the act from formal to substantive equality. It requires public bodies to be anticipatory.
What does that mean, anticipatory?
They can't just sit back and react to complaints after the fact. They have to think about the equality implications at the moment of policy formulation before they make a decision.
Can you give us an example?
Sure. Let's say an NHS trust decides to close a specific hospital wing. They must demonstrate that they have rigorously considered the impact on those with protected characteristics.
So for instance,
older people who might rely heavily on that facility, or perhaps specific ethnic groups who may have higher dependency rates there. This requirement to document and to evidence that proactive consideration, that is what critics label as crippling bureaucracy and a direct intrusion into policymaking.
So we have a law that's rooted in popular ideas of fairness, but critics insist it's a destructive force. The core of their argument, as you've highlighted, is that the act represents this unacceptable shift from formal equality to substantive equality. Let's really dig into that ideological gulf.
The ideological war is really over the purpose of law itself. Formal equality, which is what critics champion as the common law ideal, insists that the law must be blind to differences.
Treat everyone the same.
Exactly. Treat everyone the same, and if individuals fail to succeed, that's down to circumstance or individual merit, not a systemic fault. The law's job is simply to ensure equal procedures for all.
But substantive equality says that's not enough.
Substantive equality, which is the EA's mission, argues that formal equality fails when historical disadvantage has created structural barriers.
Like the steps at Arthur's pub.
Precisely. Treating Arthur the same as a non-disabled person by telling them both they can use the steps doesn't achieve equality. Therefore, substantive equality demands proactive legal intervention.
Accommodations, duties, specific policies.
All of it, to ensure equal results or equal outcomes for groups that are marginalized, and critics view this as unwarranted state-sponsored social engineering.
This is why that charge of Americanization is so potent in the UK debate. It suggests we're importing a group rights, grievance-based culture that's alien to our own legal tradition.
That's precisely the rhetorical device they use. They claim the Act, which was influenced by global legal trends and EU directives, has eroded the common law emphasis on individual liberty and procedural justice.
So it's seen as a foreign imposition.
In a way, yes. They argue it has introduced concepts like unjust enrichment and collective grievance that empower, in their words, activist lawyers and regulatory bodies, quangos, to challenge legitimate business practices simply because those practices yield statistically unequal outcomes.
So the argument is that it fundamentally changes the relationship between the citizen and the state.
Yes, tilting power away from the individual and toward the group.
And the practical result of this ideological clash is this desire to dismantle the proactive elements of the Act, specifically those mechanisms of substantive equality. Let's look at their primary targets for repeal.
The goal is very clear. Strip the law back so it only covers direct discrimination.
Which they see as explicit, intentional malice.
Right, and to do that, they aim to eliminate three key concepts. First on the list is indirect discrimination.
Okay, what is that?
This is the prohibition on seemingly neutral practices that disproportionately disadvantage a protected group. Critics see this as the main lever used to force businesses and public bodies to engineer group outcomes, rather than ensuring true individual fairness.
You mentioned an example earlier. Let's get really specific to demonstrate the scale of the critics' objection here.
Okay, let's consider a major supermarket chain. They mandate that all applicants for a management training scheme must have a minimum of 5 years of continuous, full-time professional experience.
On paper, that sounds neutral.
It sounds completely neutral. However, that requirement could constitute indirect sex discrimination because women are statistically more likely to have career breaks for child-rearing or maternity.
Meaning they are disproportionately excluded from the scheme.
Exactly. And if the supermarket can't prove that those 5 continuous years are absolutely vital for the job, for example, if 3 years of experience would actually suffice, then the policy is discriminatory.
In critics' view.
Critics see this kind of legal challenge as an attack on legitimate business standards. They accuse the law of rewarding people who failed to adhere to career norms just to achieve diversity targets.
Okay, so that's indirect discrimination. What's the second target?
The second target is positive action.
Not positive discrimination.
No, positive action. It allows employers to take proportionate steps to address underrepresentation, but only where it exists. It's a very limited allowance. It does not permit quotas or automatic selection based on group status.
The critics argue it's a slippery slope.
They do. They claim that even allowing a preference for an underrepresented group when 2 candidates are deemed equally qualified undermines meritocracy.
Their argument is that merit should be the only consideration.
The only one, regardless of background. They say these provisions promote people based on group membership rather than pure talent, and that leads to a long-term decline in institutional quality.
And they also target the equal value pay clauses, right?
Oh, absolutely. The idea that courts or consultants can deem different types of work to be of equal value and therefore deserving of equal pay, they see that as a massive overreach into labor relations.
And finally, the PSED comes under fire again, accused of embedding specific, non-neutral worldviews.
The critique of the PSED is that it forces organizations to adopt specific, often highly contested ideological stances in the name of advancing equality.
What kind of examples do they use?
Critics point to examples where public funds are allegedly diverted to training programs based on, fringe social theories, or initiatives that prioritize symbolic gestures like painting rainbows on roads or hiring highly paid DEI officers over essential services.
Like fixing roads or providing basic patient care.
Exactly. The PSED, they argue, acts as a Trojan horse, forcing political compliance onto institutions that should be politically impartial.
So the ideological battle is clear. Individual rights versus group outcomes. But every battle has a budget. How much does this whole operation actually cost the taxpayer, according to the critics?
They argue the cost of the DEI bureaucracy, fueled by the PSED, is astronomical. They cite figures, often aggregated across complex organizations.
Like the NHS.
Like the NHS, yes. They estimate nearly $40 million annually is spent on DEI roles just within the NHS Confederation. They claim this is a colossal waste, especially when the health service is under such severe financial strain.
But here's the question. Is that $40 million on diversity roles simply wasted money? Or does some of that funding ensure compliance that avoids costly litigation later? Is that IEA figure just a headline grabber, divorced from the necessity of running a legally compliant massive organization like the NHS?
That's a crucial distinction that often gets lost in the political noise. Compliance roles are expensive, yes, but they aren't necessarily frivolous.
Because non-compliance can be even more expensive.
Massively so. Non-compliance, especially within an organization the size of the NHS, can lead to widespread, costly litigation, significant financial damages, and huge reputational harm. Furthermore, poor equality practices lead to high staff turnover and burnout among marginalized groups, which is itself a huge operational cost.
So the critics frame the cost as pure expenditure, but they don't acknowledge the mitigating financial risk that those roles are designed to prevent.
That's it. Similarly, the litigation figures are used to fuel the narrative of a corrosive grievance culture.
You mean the fact that only 5% of race discrimination claims filed since 2017 were upheld at the tribunal stage?
Precisely. That's presented as proof that the law encourages malicious, ill-founded claims.
But that argument ignores the systemic barriers.
It completely ignores them. The immense stress, the complexity of proving your case, the financial pressure, all of that leads the majority of legitimate claimants to settle or just drop their cases long before the hearing stage. The low success rate is more likely a reflection of an inaccessible judicial system than a pervasive culture of victimhood.
Right, so if the battle in that last section was over bureaucracy and cost, this next battle is over definition and identity, and this is what has fueled the deepest political intensity. The language in the Equality Act around sex has become a profound legal and cultural flashpoint. What is the core legal conflict here, specifically regarding trans and gender-diverse people's rights?
The core conflict lies in defining the protected characteristic sex. Does sex mean the biological sex assigned at birth, or does it mean the legal sex attained by someone who holds a gender recognition certificate, a GRC?
And for many years, that was ambiguous.
It was. It allowed for varied interpretation, but as the political debate over trans rights intensified, clarity became essential and highly contested.
This tension then spilled directly into the political arena, leading to multiple petitions being debated in Westminster in 2023. What were the specific political objectives driving those calls for amendment?
Well, you had groups advocating for a change to biological sex, arguing that the definition needed to be tightened to protect spaces and services traditionally intended for natal women.
Things like prisons, changing facilities, single-sex sports?
Exactly. They argued that if a GRC changed a person's legal sex for all purposes of the Equality Act, then the single-sex exceptions, which allow for discrimination based on sex, would become meaningless. They said this would compromise women's safety and privacy.
And on the other side.
Conversely, LGBTQIA+ advocates argued that such an amendment would be a catastrophic legal rollback. They maintain that trans people who have transitioned and obtained a GRC should be treated entirely as their required gender for all legal purposes, including the EA.
And that the existing exceptions were sufficient if they were applied correctly.
Correctly and proportionately, yes. The situation then became even more complicated when the government's own equality watchdog, the Equalities and Human Rights Commission, the EHRC, weighed in.
What did they say?
They suggested that amending the definition of sex to include biological sex, perhaps only for specific provisions, might bring greater clarity. And that move itself just demonstrated the level of confusion and uncertainty that critics claim the act has introduced into policymaking.
So we had maximum political heat and regulatory confusion. How did the UK Supreme Court attempt to clarify things in that landmark April 2025 ruling for Women Scotland Ltd v. the Scottish Ministers?
The Supreme Court ruling provided a significant legal anchor, but it was very specific. It addressed the scope of single-sex services.
Okay, so what did it find?
The court found that for the purposes of the single-sex exceptions, those are outlined in Part 7 of Schedule 3 of the EA 2010, the provisions allowing certain services to restrict access based on sex. The definition of woman, man, and sex refers only to biological sex.
This was a highly technical ruling, but it had immense cultural resonance. What was the judge's rationale for that finding?
The judge's rationale was practical. They determined that the single-sex exceptions were written into the Act specifically to allow organizations to distinguish between men and women for reasons of safety, privacy, or dignity. They reasoned that if sex were defined by GRC status for these specific purposes, the exceptions would become functionally redundant, and that would undermine the specific protections the Act intended to give to women.
However, the court insisted on a crucial caveat.
A very crucial caveat. Lord Hodge stressed that this interpretation of sex applied specifically and narrowly to these single-sex service exceptions.
So not a blanket redefinition.
Not at all. He was explicit that this ruling did not invalidate the Gender Recognition Act of 2004, nor did it affect the EA's broader protections against discrimination based on gender reassignment.
And they warned against misinterpreting it.
They did. The judges noted the vulnerability of trans people and warned specifically against interpreting the judgment as a triumph of one or more groups in our society at the expense of another.
So the highest court in the land attempted to maintain the balance, clarifying the narrow exceptions while reaffirming the core protections. Why, then, do political calls for wholesale repeal or amendment persist even after this legal clarity?
Because the political argument transcends the legal reality. Critics argue that the complexity remains too high. They claim that the existence of the GRC, coupled with the need for organizations to conduct these complex proportionality assessments every time they want to apply the single-sex exception.
It still allows aggressive activists to shamelessly weaponize the Equality Act against organizations. That's the claim.
That is the claim. They argue that organizations, schools, hospitals, local authorities are inherently risk-averse and financially constrained.
So they'll just avoid it.
They'll avoid it. Facing the threat of a high-profile, emotionally charged, and lengthy legal battle, many organizations will simply avoid implementing the single-sex exception altogether, even though they legally could.
So the political movement wants something simpler.
They want to replace the complex legal test with a simple, unassailable statement that sex is biological sex. They argue this would immediately simplify compliance, reduce legal risk, and stop the perceived weaponization tactic by activists who seek to financially pressure organizations into ideological compliance.
If we look at the bigger picture, this entire high-stakes legal debate just reinforces the critics' overarching narrative, that the act is inherently confusing, leading to bureaucracy, expense, and a breakdown of common sense.
It serves as perfect political ammunition. The complexity of defining sex becomes prima facie evidence that the entire legislative structure is flawed and requires dismantling in favor of a simpler, less interventionist common law model.
We've established the intense philosophical, financial, and cultural battles surrounding the Equality Act. But let's circle back to the citizens the act is actually meant to protect. What does the data tell us about the real prevalence of discrimination and, critically, the effectiveness of this legal safety net?
The numbers are stark. They demonstrate a massive gap between the rights that are enshrined in law and the reality of lived experience. Discrimination is not an isolated event, it is systemic.
Oh, systemic.
A recent survey found that a staggering 1 in 5, that's 20% of working-age adults, reported experiencing some form of discrimination in the labor market over the past year alone.
1 in 5. And I assume when we drill down into specific protected groups, the prevalence becomes even more alarming.
Absolutely. When you look at subgroups, the rates are highly concentrated. Over 1/5, 21%, of ethnic minority workers report facing race or ethnicity discrimination.
And for workers with a disability.
Between 15% and 16% reported disability discrimination. This means that for marginalized groups, discrimination isn't just a possibility, it's a constant threat and a structural barrier to economic participation.
And we also see the compounding effect of intersectionality.
We do. Workers from ethnic minority backgrounds and those with disabilities are significantly more likely to face discrimination across multiple categories, sex, age, ethnicity, than their white counterparts or those without disabilities. The law's attempt to address these multiple dimensions of inequality is clearly necessary, given the data.
So given this high prevalence of these experiences, the legal system for delivering justice must be completely overwhelmed. Yet the data shows the opposite. Very few cases actually make it through the courts.
The legal safety net is just not working. The individual legal route, the employment tribunal, or ET, is failing to deliver justice for the vast majority.
How badly is it failing?
Well, 2/5 of all ET applications involve discrimination, but this still represents a minuscule proportion of the reported incidents. Consider disability. Roughly only 1 in every 243 cases reported ultimately proceeds to an employment tribunal hearing.
1 in 243. That's an incredible failure rate. The system is designed to be inaccessible.
It seems that way.
Why are so few cases progressing? Is it the financial cost, the time, the complexity?
It's all three, but the emotional and financial deterrents are the most powerful. Discrimination cases are lengthy, complex, and emotionally grueling. They often take a year or more just to reach a hearing.
A process that heavily favors those with resources.
It heavily favors higher earners and large organizations who can absorb the costs, the time commitment, and the resilience required to navigate that adversarial process.
And we know that claimants settle out of court at extremely high rates.
Between 66% and 80%. And not because they're satisfied with the outcome, but because they cite stress, 48% of discrimination claimants, and financial concerns as the primary reasons for giving up.
The system turns the pursuit of justice into a battle of endurance that the financially and emotionally vulnerable can rarely win.
That's a very good way of putting it.
And all the while, the state body that's responsible for strategic enforcement, the EHRC, has been starved of resources.
The constraint is severe. The EHRC's budget has been cut by 4/5 since 2008-09 in real terms.
4/5?
Yes. They lack the resources and the legal powers, like the ability to issue direct financial penalties or conduct proactive inspections like a dedicated regulator could.
So they're forced to be highly selective.
They have to be. They pursue only a handful of strategic cases annually, which leaves the mass of individual workers reliant on this flawed, inaccessible ET system. The system intended to enforce substantive equality is operating at a fraction of the capacity required.
This brings us right back to the great paradox, but through the lens of individual protection. If critics succeed in stripping away this legal foundation, the Equality Act, what are the unintended, ultimate consequences for the liberal society they claim to be defending?
Let's anchor this to the example of Yasmin. She is a secular teacher who fled a fundamentalist regime to come to the UK, valuing its liberalism.
Okay.
She is currently protected by the EA against discrimination based on religion or belief, and on sex, from her school's board of governors, who want to impose conservative religious strictures on her personal life.
Right, so the act is her shield.
It's her secular shield. If the Equality Act is repealed, the UK removes the primary legal shield that protects individuals from arbitrary rule. The critics say they want to stop external intolerant ideologies, but by removing the EA, they remove the legal protection that shields UK citizens from internal pressures for conformity.
Regardless of where those pressures come from.
Exactly. Regardless of whether they come from religious conservatism, old-school institutional sexism, or just local prejudice.
So this means that by tearing up the legal framework to fight what they see as a foreign-driven social justice ideology, they are actually enabling the return of old intolerances and hierarchies. The very thing the act was designed to prevent.
It's cultural self-sabotage. The legal framework of the EA is the country's moral immune system against arbitrary discrimination. Dismantling it removes the barrier that prevents the tiny minority who want a deeply exclusionary, regressive society, a society based on first and second-class citizenship, from enforcing their dogmas.
You create a legal vacuum.
You create a vacuum, a hollowed-out shell that's ripe for the exact forces of intolerance that the critics claim to be fighting. They destroy the shield in the name of defending the fortress.
So we've seen that the Equality Act is fundamental to modern British identity, rooted in dignity and fairness, but its complexity, its cost, and its ideological reach have made it an intense political target.
Absolutely.
The enforcement system is clearly flawed, It favors high earners and deters others because of stress and cost. But the moral intention of the law is clear: to ensure dignity and practical fairness across all groups.
The fundamental conflict remains between that common law principle of individual formal equality and the practical goal of substantive equality across groups.
And the paradox is that in seeking to restore the former by destroying the EA,
they risk enabling profound inequality that undermines the UK's reputation as a champion of human rights and exposes vulnerable people to arbitrary, unprotected discrimination.
ultimately, the question for the UK is not whether we defend British culture, but whether we acknowledge that the Equality Act, with its commitment to dignity and practical fairness for all its citizens, is the culture we should be defending. If the law is fundamentally good, but the implementation is failing, where is the solution?
The solution, I think, lies in fixing the machinery of justice, not destroying the rights themselves. Given the high prevalence of discrimination and the failure of the adversarial employment tribunal system, we have to focus on accessible enforcement.
And there are models we can look to.
We can look at effective models internationally, such as the German Federal Anti-Discrimination Agency, or FA.
And what do they do differently?
F8A acts as an independent single point of contact that focuses heavily on providing free advice, conducting accessible, low-cost mediation, and offering initial legal support.
So it shifts the process away from the high-stakes court battle that defines the UK's ET system.
It does. It makes justice accessible without sacrificing the core rights that are guaranteed by the Act.
Focusing on accessibility and mediation, that seems like the responsible path forward. It addresses the critiques of cost and litigation culture without sacrificing the core, modern values of fairness and dignity that define contemporary British life.
Indeed, it allows the country to meet its legal commitments without imposing that terrible financial and emotional burden on the very people the law is meant to protect.
That seems like the necessary next deep dive: how to fix the engine of equality without burning down the house. Thank you for walking us through this incredibly complex landscape.